Lawyer Paul Kume, constitutional legal practitioner. Thank you very much for your time. Good morning.
Good morning. My pleasure.
I hope you're doing well.
Great.
First of all, let me start by asking whether you have some issues with the Speaker's action when it came to the issues that were raised by the fact that the Member of Parliament of Sevi also drew his attention to the fact your comments are prejudicial and it does not lie in your mouth to say that. Was the Speaker right when he said it was rude?
Yes, he did not draw the Speaker's attention to anything. It was simply rude. What the Speaker was saying was in respect of a general issue. You know, there has been an issue about the capping. There has been a complaint that to the extent that there is no capping, the President can appoint as many persons to the Supreme Court as he wishes. So the Speaker was more or less suggesting to members that if they felt so strongly about that issue of the President appointing many people to the Supreme Court, they know what to do. And he indicated the need for them to initiate a bill to ensure that at least such a cap can be brought about. He might have misconstrued that statement by the Speaker as affecting those two persons probably who were going to be vetted. So that probably he was saying those things to ask members of the appointment committee probably to refuse the appointment of those two persons as nominated by the President. He got the whole thing wrong. You see, and then what is more, he had made that remark, and I think because he had not spoken into the microphone, it is presumed as a statement not made or heard by the Speaker. So to the extent of the Speaker even saying that, oh, Honorable, I thought I heard you say something. Would you want to repeat it? Then you get up. I'm sure a lot of you have probably watched the clip.
Yes.
The body language and everything. I mean, it's so insulting. And one did not expect somebody who calls himself an honorable member of parliament to have such a behavior. And the choice of words that it does not lie in his mouth. It does lie in the mouth of the Speaker to advise as to what can be done to, as it were, check something which all of us are complaining about. So if he misconstrued or misunderstood what the Speaker was saying, one would have expected him to have said, oh, Mr. Speaker, what you are saying, is it in respect of these two appointees or nominees or what? But not to get up, talk, and then violently even switch yourself off on the microphone. I'm sure you saw it. I mean, it's not good enough. You see, some of us are a bit worried. We are not worried just because of politics, but we are worried because there are lots of up-and-coming persons who are looking for persons who can be their role models. So it is possible that both Honorable Member of Parliament might have had somebody who is always looking up to him as a role model and will want to become what he is currently one day. Will such a walkout, I mean he's being dismissed from Parliament by the Speaker. Will this be a very positive thing to that particular person who is looking up to him for inspiration or to see him as a role model? That's one thing which is a bit hurting.
Well, so it seems then you agree with the action of the Speaker to walk
more than agreeing with him. Yes, I know that the Speaker might have done some of these things out of anger, and he's a bit human, and so probably what the Speaker could have asked him to do will have been to ask him to withdraw what he said, and then and apologize. Now, if he fails to do that, then the Speaker can walk him out. But those are options available to the Speaker. The Speaker, by his assessment of the whole situation, felt that he has been disrespectful to him. And that's the reason for which he asked him to go out. Note something which happened. When Doctor was going out, at least I'll give that one to him. When he had given me asked to be walked out by the marshal, before he left the chamber, You realize he, curtsy. I mean, he had to now bow in respect to the chair. So that is what he should have had at the back of his mind at the time he got up and was talking and was showing such gross disrespect.
Interesting. Now, having said that, what do you make of the tone of the letter that the speaker read from the president? Do you agree with the president when he talks about the fact that he needed to make these nominations to ensure that the Supreme Court has the full complement of judges?
Good. So you realize that was what might have compelled the speaker to make the comment. You see, when you read Article 128, 1 and 2, it talks about the least number of persons who should be Supreme Court justices. You should have the Chief Justice and not less than 9 other persons. Now, we now have about 15, getting closer even to 20. Now, so when the president should come and be saying that, oh, there are some 2 people who are leaving, and so we need to have some replacement for those 2 people, it means we are gradually making that current number as an established number, which should not be lower than what it should be. And so the view of the speaker was that, judging from the justification which is being given for the appointment of these 2 other, for the nomination of these 2 persons to the Supreme Court, there is a need for us to probably see if we can do something about it. Indeed, when you look at the timeline that is required, even for what the speaker is suggesting, it is something that cannot be done within the life of this particular parliament. I mean, looking at the campaign, which is just of 120 or so days away, so it's not going to be possible. But I believe that he just threw this one out, so that even if it is not done during the lifetime of this particular parliament, any new parliament which will come after 2024, that's it, the 2025 parliament, will probably consider that one as one of the things that you should look at. Fortunately, this particular issue regarding the appointment of Supreme Court justices are not part of the entrenched clause. It's something that can be done, by Parliament itself. But of course, after it has gone through various processes as indicated in the Constitution.
But is the letter also not, don't you have because of the tone of the letter, is there not a possibility that maybe a member of the appointments committee who disagrees with the thoughts of the president, because the president seemed to be saying that as far as he is concerned, the full complement of the Supreme Court is the Chief Justice plus 15 other Supreme Court justices? Or did I get that wrong? That's what he is suggesting.
No, what I'm saying is that what is clearly stated in the Constitution is the Chief Justice and that 9 other justices. That's the least number that we should have at the Supreme Court as judges. There is no cap. So it can get to 100, it can get to 2,000 if there are such number of justices who can fill the Supreme Court. Right? And so if anybody is going to make any observation and he is going to make reference to the fact that the Supreme Court is being packed or we are having too many members or too many justices being sent to the Supreme Court, that argument will not wash because the Constitution did not give a cap. What you can use against any particular nominee may be the fact that he is not of high moral character, he doesn't have the wherewithal to be effective as an appointee of the Supreme Court. Those are the issues you can raise. But if you are going to be talking about numbers, that one wouldn't wash now because the Constitution will not support you. So whether the president is of the view that 15 is the the apt number or the optimum number with which he thinks that the Supreme Court can work with, that's another matter. You realize that in this particular appointment, the president makes it clear that he was advised by the Judicial Council, right? And it is based upon that that he has also nominated this person. So the earlier letter that went round where the Chief Justice was suggesting names to the president obviously was wrong, because that is not how that should be done. So I believe that what has been done in respect of these two nominees is the way as espoused in the Constitution. And I believe that these two officers will have to be looked at in respect of their expertise and what they are going to bring on board. And to the extent that there is no cap currently, I do not think that we can use that as an issue to, as it were, deprive them of the opportunity given them.
But do you agree with the Speaker when he says that ultimately we have to look at the issue of a limit?
Yes, I agree with the Speaker to the extent that, yes, we will need to have a cap. Because if we don't do that, we will continue going on and on and on and on. So his remarks yesterday was essentially to tell the members of Parliament that we cannot just be sitting down and be complaining about some of these things. There are ways by which this cap can be brought about. And so let's go ahead, get a bill, go through the various processes, and then we as Parliament can approve of it. This, as I said, this is not one of the entrenched ones. When it comes to the entrenched process, it will have to go for a referendum. This particular one will not have to go for a referendum. It will just have to go through the Council of State, some gazetting, publication for some number of months, and then Parliament can pass it, and then the President can, assent to it, and that one becomes a new provision of the Constitution.
But let me conclude with you by asking you, do you know any of the two persons who have been put forward, Justice Bernard Kwesa, Professor Richard Frimpong-Opong?
Yes, I know Professor Frimpong-Opong. He happens to be my mate at the law school. During our year, he swept almost all the prizes. He is a gift to the Supreme Court. And he is one person that I am really, really excited to see him. The kind of contribution that he's making worldwide, especially in Canada and others. I thank God that at least he's found it necessary to forget about the dollars and to come down to Ghana and then put his expertise also at the disposal of his motherland. In respect of the other nominee, she is also one great lady. She is also very good at law, having been a state attorney and all that. So she also has a full mastery over the law. And I believe that these two persons, when approved, there will be a huge asset to the Supreme Court.
Always a pleasure talking to you.
Same here.